At this point, we've been looking at how we scale the rights and obligations of contract via agency law. For this last video, we need to switch gears and think about a different area of law, the tort of negligence. So when you're operating a business, you've got a lot of people working for you. And the question is, how liable are you for what they do, for their acts of carelessness? And to understand this, we need to turn to the area of vicarious liability. Vicarious liability actually allows for the scaling of carelessness by the employees and attaches that liability to the employer, whether that's a person or a legal person like a corporation. Generally, we're going to think about it for this course in terms of employer-employee relationship. Now, when you hear that, it might be a little misleading because it covers more than those under a traditional employment contract. In fact, the courts don't just look at whether there is this traditional contract of employment between the two parties. They look at something called the control test. Some people call it the factors test. We're going to talk about the control test. Does the business owner have control over the worker? So let's look at that in a little more detail. As we've been discussing, vicarious liability arises frequently in the employer-employee relationship. And while it's pretty straightforward in a traditional employment relationship, many times businesses are creating new kinds of relationships. One of the reasons is to limit their liability. They start employing people under terms like independent contractor. It's also an important consideration given the rise of things like the gig economy and internet facilitated work. So what actually happens when someone is termed a contractor but is in an employment-like relationship? In these situations, the courts apply the control test rather than the label that the parties put to their relationship. In this control test, they're looking at the sum of the relationship, the totality of the relationship, and in particular, they're looking at how much control the business has over what the workers does. Now, the classic case of this is Hollis and Vabu, which, as my little bike suggests here, involves a bicycle. And so there was a bicycle courier that actually struck a person as they were making a delivery. And the person who got knocked over didn't actually talk to the person who hit them because they just sped off. But what they did do is they could see the uniform of the bicycle courier company, Vabu. And the individual who suffered some harm because of the carelessness of the bicycle rider then took action against the company that the bicycle courier worked for. But Vabu said that their bicycle riders were independent contractors, not employees, and therefore they weren't vicariously liable. Well, the courts had a look at the actual relationship, and as part of this court case, they set out a number of factors. And you can see in the actual court case here, where they're talking about the company, Vabu, retain control of the allocation and direction of the deliveries. The couriers had little latitude. Their work was allocated by Vabu. They had to deliver goods in the manner in which Vabu did. So you can see here the court is saying Vabu had control over how the work was done. They were also showing that Vabu had control over the allocation and direction, so there was little ability of the workers to actually influence what work they did. And then finally, the workers had to wear a uniform, which is another sign that an employee of Vabu rather than an independent contractors. So again, this test is not one factor on its own, but it's looking at the various things that point to control of the business over the worker. And in the case of Vabu, despite being labelled this independent contractor, the court held that this was an employer-employee relationship. Hopefully that makes sense, right? It doesn't matter what the label is. If it's the kind of relationship where the business has control over the worker, the court will find that the business is vicariously liable for the actions of that worker. Okay, that's fairly straightforward. But what happens if the worker does something that's, stupid? What I'm really trying to point to is the business liable for every action that a worker takes. So for instance, is QUT liable for, what I do at the discotheque on Saturday night in the city? Right? Now, hopefully you're starting to see, well, that seems a bit stupid. Yeah, it would be, right? So then we've got to understand what's the limits of this liability. Where does the business liabilities end? And to do this, we've got to understand the difference between authorised work done in an unauthorised manner and unauthorised work. And we've got the case here of Century Insurance and Northern Ireland Road Transport Board to help us out. Let's have a look. So we already know that we apply the control test to see if there's an employer-employee relationship. Once we've done that, we look at what employee actually did, and we've got to ask, were they acting in the course of their employment? Was it something that involved them doing their job? If they're doing their job, if they're doing authorised work, but they're doing it the wrong way, the employer is liable. Even if they're going against policy, it's all about what they're doing. Are they doing their job? Are they doing authorised work? But an employer is not vicariously liable for actions that aren't part of their employment. Okay, let's look at this first point in Century Insurance Company. I think it's a great case. And so what we had was a petrol tanker, and it was at the time unloading petrol at a petrol station. And the person unloading the petrol tanker decided to have a cigarette as they were unloading it. Now, as you can imagine, that didn't end well. Clearly in this case, what the worker did was against policy. You weren't allowed to have a cigarette while you're unloading a petrol tanker if you're working for a trucking company. But what the courts held was he was doing authorised work. He was authorised to unload petrol. And because that work was authorised, it doesn't matter that the worker did it against policy, even something stupid like this. The employer was vicariously liable. Why? Because the petrol tank driver in this case was doing authorised work, unloading the tanker, but doing it in an unauthorised manner while having a cigarette. That means the employer is liable. So hopefully that makes sense. If the worker is doing something that's part of their job, including minor deviations from part of their job, then the employer will be liable. They should really be exercising their control and making sure the worker's doing it the right way. And so those two rules are the key to understanding vicarious liability. Rule number one, we've got to apply the control test, not worry about the labels that the various parties give each other in any particular case. So we look at who's in charge of deciding how the work's done, who allocates the work and has a right to say no. Are there any kind of uniforms or any signs that the person is actually employed by the business, that the person is actually controlled by the business? Once we establish an employer-employee or a control relationship, then we need to ask, was what the employee doing authorised, like the petrol tank driver, even if they did it in an unauthorised manner? Or was it unauthorised work? So unauthorised work would be, me going to the discotheque on Saturday night and seeing you and slapping you on the back, right? QUT has not authorised me to do that. But if I did something stupid in a tutorial, if I got you to dance on the desks and you fell off, then QUT would be liable because I'm doing an authorised act. I'm running a tutorial, even if I'm doing it in an unsafe or an unauthorised way against the work health and safety policies. So that's the key difference there. And with those two rules, we have a fairly good way of understanding when a business is liable for what its employees